Hi, hello, good evening. Welcome back to National IAS Academy. Dear friends, my name is Rajshekhar Bisnalli. I shall be your mentor for this particular initiative. So it is called as Focus 300. So for all those who are watching our video for the first time, let me brief you about the new initiative. It is called as Focus 300, and over a period of next 30 days, we shall be covering 300 most highly relevant important topics for the upcoming UPSC Civil Services examination, that too preliminary. So this initiative is actually aimed at helping all those aspirants who are writing their prelims on 28th of May 2023. So every day we shall be uploading one video consisting of 10 most important topics for 30 days, covering 300 most probable, highly, very relevant topics for the upcoming civil services examination. So with that being said, let us not waste much time and straight away begin with our third class. In previous two classes, I have already covered 20 most important topics. So today we shall cover 21 to 30. So it includes standing deposit facility, additional tier 1 bonds, article 142 of the Indian Constitution, 103rd constitutional amendment, sedition law, right to abortion to unmarried women, guidelines for granting bail, daughters' right to inherit self-acquired property, prevention of money laundering act, which was amended in 2021. Then we'll also look at the meanings of short selling, buyback in the context of short market. So straight away let us begin with the first topic, that is standing deposit facility. It is a new kind of facility introduced by the Reserve Bank of India in the year 2018. But before that, in the year 2014, this facility or the information regarding the introduction of this facility was mentioned by Urjit Patel Committee. A committee headed by Dr. Urjit Patel recommended the introduction of standing deposit facility in the year 2014, and it was officially introduced in the year 2018. What does this mean? What is the meaning of standing deposit facility? See, it's a form of loan being or credit facility or loan facility being provided by the Reserve Bank of India to the banks in India without the need for guarantee or a collateral, without the need for collateral or guarantee. I repeat, standing deposit facility mean credit or loan given by the Reserve Bank of India to the respective or banks who are in need of money without the need for collateral or a bond, government bond. So what is the objective? The objective is to handle or manage liquidity in the market. Whenever there is high liquidity in the market, RBI absorbs money from the market, and whenever there is low liquidity in the market, RBI injects money into the market through or with the help of various financial instruments. And in that regard, SDF is new financial instrument. Alright. So what happened before the introduction of SDF? Before the introduction of SDF, if banks wanted to take some money overnight through various available facilities from the Reserve Bank of India, they needed collateral. Collateral mean government securities or treasury bills. So once they pledge these collateral, only then they would be allowed to take excess funds from the RBI. It might be on the basis of reverse repo or repo rate. But with the introduction of SDF, the banks no more need any collateral as a guarantee. So in case they require any excess fund, without the help of collateral, they can directly approach the Reserve Bank of India and apply for some additional extra funds. Then what is the rate at which SDF is being provided? Right now it is at 3.75%. So this is 25 basis points higher than repo rate. Please note, the rate at which SDF is being provided is 25 basis points higher than the repo rate and 25 basis point lower than reverse repo rate. Please don't get confused. The rate at which SDF is being provided is 3.75%. This is 25 basis points higher than repo rate and 25 basis points lower than reverse repo rate. Now, please comment in the comment section below the difference between repo rate and reverse repo rate. What is the major difference between reverse repo and repo rate? Please do not forget to comment your answers in the comment section below. Alright, next we have something called as additional tier 1 bonds. What are these bonds? Why are they helpful? What are the benefits associated with these bonds? And what are the parallel risks associated? Dear friends, additional tier 1 bonds are also called as perpetual bonds. Additional tier 1 bonds are also called as perpetual bonds, meaning they are kind of permanent, which means they don't have any maturity. So that is why they are called as perpetual bonds. So these bonds are usually issued by the national level banks to raise capital. Why? To meet the additional capital requirements set up by Basel III norms. Additional capital that is required as per the Basel III norms are met by these banks by issuing additional tier 1 or tier 1 bonds to various institutions, not individuals. Individuals cannot buy these bonds. Only institutions such as mutual funds or any entity can go for these bonds, right? So the meaning of these bonds is they are perpetual, which means they don't have any maturity. Then what are the benefits associated with these kind of bonds? The major benefit is interest rate. Any FD or fixed deposit that is parked in a bank is given not more than 5% of interest rate. So a FD, large sum of FD parked in any bank would not get more than 5% of returns. Whereas returns on or interest rate on additional tier 1 bonds would be more than 7%. In some cases, it would be nearly 9%. So this is the major benefit that is associated with respect to additional tier 1 bonds. Alright, then what are the risks associated? These are unsecured bonds. These are unsecured bonds, which means there is no guarantee or security being provided by the issuing bank to the beneficiary, which means in case of any risk or any failure of that particular bank, the bank is not compelled to pay any compensation or even the interest in some cases to the beneficiaries. Hence, these are very risky bonds. All right. Why this was in news? Recently, this SECI, that is SEBI, Security Exchange Board of India, and Bombay High Court have expressed major concerns regarding the usage of these bonds, because Yes Bank had duped customers by issuing these bonds, blindly to these customers without informing the risks associated with the kind of these bonds. Right. Next, we have Article 142 of the Indian Constitution. What does it speak about? So it talks about the discretionary power given by the Constitution of India to whom? To the Supreme Court. Remember, Article 142 talks about this discretionary power or original power given to the Supreme Court of India by the Constitution of India. What does it say? It provides discretionary power to the Supreme Court and states that the Supreme Court, in the exercise of its jurisdiction, may pass such decree or make such order as is necessary for doing complete justice in any cause or matter pending before it. So, Article 142, first point is related to the Supreme Court of India. Please note it down. Second, it talks about the discretionary power of whom? Of the Supreme Court. Third one, what does it seek to provide, or what is it aimed at? It is aimed at providing complete justice. So why was it in news? In 2022, in Babri Masjid case, the Supreme Court of India invoked this particular article to club all those pending individual cases with regard to Babri Masjid case or Rama Janmabhoomi case into one case and provided its verdict. Alright. Next, I have taken a question which is similar to this discretionary power of Article 122, which was asked in the year 2019. The question says, with reference to the Constitution of India, prohibitions or limitations or provisions contained in ordinary laws cannot act as prohibitions or limitations on the constitutional powers under Article 142. It could mean which one of the following? It is a straightforward question. He is asking the meaning of the Article 142 of the Indian Constitution. The examiner is asking, what does Article 142 talk about, or what is it related to? By looking at the options, you can easily eliminate Article option A and option C because they seem extreme, for the given situation. It says, statement 1 says, the decisions taken by the Election Commission of India while discharging its duties cannot be challenged in any court of law. This is straight away an extreme statement which cannot be justified, or such kind of power cannot be given to any constitutional authority. So eliminate statement A, then look at the statement C. In the event of grave financial crisis in the country, the President of India can declare financial emergency without the counsel from the cabinet. These two shall be easily eliminated because President acts and works on the aid and advice of Council of Ministers. Please remember. Then look at statement D. State legislatures cannot make laws on certain matters without the concurrence of union legislature. This is true with respect to 7th schedule of the Indian Constitution, where the subjects are divided into 3 different categories, that is state list, union list and concurrent list. But dear friends, this is nowhere related to Article 142 of the Indian Constitution. Hence, the right option is option B, that is the Supreme Court of India is not constrained in the exercise of its powers by laws made by the Parliament. Alright. This particular article talks about the discretionary power of the Supreme Court of India. Then we have 103rd Constitutional Amendment Act, which talks about reservation given to economically weaker sections of this society. So please remember, there are 3 important points which you need to keep in mind. Article Constitutional Amendment 103 talks about the reservation. What kind of reservation? Reservation given to economically weaker sections. How much reservation is being given? 10% of reservation is being given. How? Through a Constitutional Amendment Act. This Constitutional Amendment Act has brought in amendments to Article 15 of the Indian Constitution. Please remember, this particular act has brought in amendments to Article 15 of the Indian Constitution. Alright? Not just that, it has even brought amendments to Article 16 of the Indian Constitution. It has introduced 2 new provisions in the Indian Constitution, Article 15 Clause 6 and Article 16 Clause 6. Alright, so let me recap. 103rd Constitutional Amendment Act seeks to provide 10% of reservations to economically weaker sections of the society by bringing in amendments, 2 amendments, that is one amendment to Article 15 and another amendment to Article 16 of the Indian Constitution. So it was held perfect with respect to Indian Constitution in September 2022 by the Supreme Court of India. There were various petitions charged against this constitutional amendment. However, they were disposed and the amendment was held valid by the Supreme Court of India in 2022. Right? Then, based on what criteria is EWS reservation decided? First one, the beneficiaries should have household income of less than 8 lakh a year. At least 95% or 127 crore of Indians fall under this particular criteria or become eligible as per this criteria. But that is not it. Second criteria is they should have agricultural land of less than 5 acres. Third is have a house smaller than 1000 square feet. Fourth, they should have a residential plot smaller than 100 yards in municipality. Alright. Then the fifth requirement is they should have a residential plot of less than 200 yards in a non-notified municipality. So these 5 criteria or requirements should be met to become a beneficiary under EWS category. And please remember, in its September 2022 judgment, the Supreme Court clarified that the EWS reservation does not violate the 50% ceiling set by the Mandal Commission. Please remember this point. A 50% reservation ceiling was set by the Mandal Commission in 1990s. So the Supreme Court, through its judgment, has clarified that the EWS reservation shall not violate this 50% reservation set by the Mandal Commission. All right. So there was a question, related question asked in the year 2018 by the UPSC. The question is, which of the following are regarded as the main features of the rule of law? Limitations of powers, equality before law, people's responsibility to the government, liberty and civil rights. Select the correct answer using the code given below. 1 and 3, 2 and 4, 1, 2 and 4, or D, all of the above. What do you think would be the right answer? Dear friends, C, 1, 2 and 4 only is the right answer, because people's responsibility to the government has nowhere been mentioned or has nowhere been associated with the rule of law. Alright, it's not towards the government. This responsibility should have been towards the law or statute or constitution. In that case, it could have been confusing, a little confusing, but here straight away it is clear that statement 3 or third statement is irrelevant with respect to the rule of law. Next we have sedition law. It has been mentioned under section 124A of the IPC, that is Indian Penal Code, which was enacted in the year 1860. It existed even before the introduction of Indian Penal Code in 1860 in various other forms, but with the introduction of Indian Penal Code in 1860, this law or this rule was made a statute or a strict provision with respect to the Indian Constitution. Alright, so recently there was a report released by NCRB, that is National Crime Records Bureau, on the status of number of cases being registered with respect to sedition. The report says in 8 years of time, highest number of cases regarding sedition or with respect to sedition were registered in the state of Assam. So Assam, with 69 cases being registered under sedition law, stands first in the entire country with respect to the cases being registered on sedition. Second one is Haryana. Third one is Jharkhand. Please note down these points. First is Assam, second is Haryana, and third one is obviously Jharkhand. Alright? Okay. So there can also be a question regarding the Supreme Court cases related to sedition or section 124A of the Indian Penal Code. So in that case, please remember these three judgments, which are one is 1962 Kedarnath Singh versus State of Bihar, then 1982 P. Alavius, State of Kerala. Third one is 1995 Balwant Singh and ANR versus State of Punjab. So if the question is asked, which of the following cases is or are related to the sedition law in India, so you should mark all these three cases, or the question can also be this way. Section 124A of the IPC or Indian Penal Code is concerned with which of the following cases of the Supreme Court of India. Then in that case, the option or the solutions consist of these statements or these cases. Please mark them as the right option. Next, we have something about right to abortion given to unmarried women. So recently the Supreme Court of India gave pregnant women to go for abortion, to allow for abortion even beyond 22 weeks because of some genuine reasons. So while passing this judgment or while granting this right to that woman, Supreme Court highlighted Article 21 of the Indian Constitution. So what does Article 21 of the Indian Constitution talk about? Please comment in the comment box below. What does Article 21 of the Indian Constitution talk about? Don't forget. Alright. So what about the abortion law that is been in existence in India? See, before 1971, women were usually subjected to strict provisions when it comes to abortion. But with the introduction of Medical Termination of Pregnancy Act of 1971, some kind of liberal mindset was developed across the country. All right. So before the 1971 Act, it was a crime for mother or for pregnant woman to go for abortion. So as a result, if anyone opted for abortion before 1971, they could be punished. Not just them, even the practitioner or doctor could be punished, right? Unless it was severe. But with the introduction of Medical Termination of Pregnancy Act, abortion was allowed as a right, but only for 20 weeks. For 20 weeks. That too, up to 12 weeks, there was no need for any permission. But between 12 to 20 weeks, it required permission from 2 registered doctors, indicating that it has been some kind of forceful pregnancy, or the woman who is pregnant or the pregnant woman is not fit enough to carry this pregnancy ahead. So such kind of clarification should be given by at least 2 registered doctors. Only then that woman could opt for abortion. But however, since the amendment, women can opt for abortion even beyond 20 weeks, that is up to 22 weeks. Excuse me. Next we have guidelines for granting bail. What is bail? A bail is a kind of permission given to those people who have been arrested, or to those who have been convicted and are under the police custody. So guidelines for granting bail are mentioned under, the provision or the reference to bail in India has been made under the CRPC, that is Criminal Procedure Code. Even though the reference has been made under CRPC, the CRPC nowhere defines the meaning of bail, which means what is a bail has not been defined anywhere, including CRPC. All right, it only talks about it only talks about bailable and non-bailable cases. Bailable and non-bailable cases. However, bail has not been defined anywhere under the Indian Constitution or even in the CRPC. Please remember this. Right. Next, the article is about daughters' right to inherit. In 2022 September, Supreme Court passed a verdict according to which even daughters are equally entitled to inherit their father's property. But before this, it was really hard and difficult for a daughter to inherit the ancestral property. So with the introduction of Hindu Succession Act, even daughters were given the right to inherit their parents' property, but that has now once again been clarified or confirmed by the Supreme Court of India in 2022 with respect to a case which was with respect to a verdict which was passed by Madras High Court. Madras High Court had restricted this right of inheriting inheritance by female or women in their ancestral property. However, Supreme Court of India went against the verdict passed by Madras High Court and clarified that women or daughter too have equal entitlement or equal benefit when it comes to right to inheritance. All right. Next we have Prevention of Money Laundering Act. So Prevention of Money Laundering Act, which was passed in the year 2002. Money laundering or dirty money, both terms are used interchangeably. Even Financial Action Task Force is tasked with combating the laundering of money or money laundering. Usually money laundering comes into picture whenever there is an attempt by any individual or entity to convert black money to white. Whenever there is an attempt to convert black money to white, this term, that is money laundering, occurs. So those entities or those persons or those people who are involved in this process can be booked under this act, that is Prevention of Money Laundering Act, which was passed in 2002, right? And it was amended in 2012. So based on these amendments, few changes have been made. First one is under section 3 of the act, mere possession of proceeds of crime is now an offence. So earlier there were few instances wherein the influential and rich used to say that they just held, or they just were holding the money on behalf of someone else. So they were not involved in money laundering. That is why they should be released. However, with the amendments made in 2012, the law said even mere holding of such proceeds or such black money would amount to offence as per the law. Hence, even they can be booked under PMLA, that is Prevention of Money Laundering Act. And the second major change is, before this amendment, up to 30 lakh threshold limit was set for initiating money laundering cases for economic offences. So it has been done away with now. Even for as low as 10,000 rupees, the money laundering cases can be initiated now. All right. And with respect to penalty, there is no upper limit on fines now. Earlier it was rupees 5 lakh, and now there is rigorous imprisonment of at least 3 years and up to 7 years. It can be extended up to 7 years. Next, we shall discuss about short selling or buyback. What do you mean by short selling? See, short selling is nothing but wise prediction or guessing. Suppose, let's say, Akshay Kumar is here. So Akshay Kumar is not possessing any shares, but Akshay Kumar knows something about the shares related to Reliance company. So without holding any shares, he can neither sell those shares, or he can nor buy those shares. But what he does is, there is a broker. With the help of insider information, Akshay Kumar predicts that in future the share value of Reliance shares would be falling. So suppose, let's say today the market rate of one share of Reliance company is ₹100 rupees. But Akshay Kumar predicts that in future this amount 100 rupees would fall to 80. In 1 week or so, the shares of Reliance would be falling to 80 rupees per share. 100 rupees per share is present cost or today's cost. So it would fall to 80 rupees per share in 1 week. So what it does is, he calls this broker who is having some 100 shares of Reliance company and advises him to sell off those shares. So today's price is 100 rupees per share. What this broker does, he trusts Akshay Kumar and he sells these 10 shares. So in total, he is gaining 1,000 rupees, 1,000 rupees. And just like Akshay Kumar guessed, in 1 week, the share value of Reliance company or Reliance share fell to 80 rupees per share. Then Akshay Kumar advises, you now buy 100 shares. So the present value of per share is 80 rupees. So he'll buy 10 shares, which equals 800 rupees. So what happens? The broker gained or made 200 rupees of profit without any kind of extra investment. He was holding 10 shares of Reliance company. So that was valued 100 rupees 1 week ago. He sold them. He made a profit of, or he generated 1,000 rupees in total. Then after 1 week, the share value fell to 80 rupees per share. Then he thought of buying back those shares. So he bought 10 shares effectively at 800 rupees. So in reality, he saved, or he made a profit of 200 rupees out of this. He is giving 50% to Akshay Kumar. So Akshay Kumar made a profit of 100 rupees without even investing a single penny or single pie. So Akshay Kumar sitting at his home, just based on his predictions or just based on guessing, made a profit. So that profit was shared by the broker and Akshay Kumar. That is called as short selling. Understood? Short selling is nothing but making profit just based on predictions. All right. So that's it for today, guys. I hope today's session was really helpful for all of you. So if you're new to this channel, please hit the like button and also subscribe to this channel. And please don't forget to share this video with your friends. Thank you so much and see you in the next video. Take care.